We have the discussion today on gender and equal opportunity. Sometimes I'm also speaking about non-discrimination and equal opportunity. So the session will be on gender and equal opportunity, for which we have our colleague here, Francesca Biasiato, who works with me here at the center here in Turin. Um, Now, just for your information, why are these topics? These topics might seem to come ad hoc, like why is he choosing those particular topics? Well, one of the reasons many of you also completed, I think that was already in December, a learning survey, like what are the topics that are of particular interest to you? So we submitted this whole list where we ask you what are now the 3 topics that are of interest to you. And of course, these topics were also chosen based upon their presence within the ILO M&E declaration. So triangulating the interest that you had in a certain topic and also the availability of specialists from our side, we came up with this agenda. And that's also the reason why we have a topic of, for example, indigenous peoples here, where we have a Meet the Expert session. That's also why we have today's sessions on non-discrimination. That's why we have not a session on violence and harassment at work, because apparently that was not that it's not important, but maybe within your work stream it doesn't get so much attention. You are more working on topics such as wages and freedom of association. Um, Child labor, we put in there enforced labor because they are part of our fundamental principles and rights at work. Even they didn't score that high, we said we are still going to put them into the agenda. And social protection, because the topic is so big and you can go so broad, we said, well, maybe we're not going to cover it in this cycle. This is also how the agenda again looks like, and I just want to quickly go through it so we know what is the red thread through these 3 weeks, and also explain for those that join us today, because some of you were with us last week and are only joining us from today. So the first week, what we did last week on the M&E declaration, when we had the opening session and the session with Gita, was really to show how the frameworks can fit together, how you should not look at them as competing frameworks, the M&E declaration, the OECD M&E guidelines, but that they actually work best when they very much speak to each other. The guidelines speak towards the ILO M&E declaration and vice versa. And that's also how we should see them, as complementary tools. On Friday then, until this week, and this will be the theme of the whole week, we just have some focus sessions on specific topics on business and international labor standards, just for you also to understand what is behind these principles that are in the ILO M&E declaration and the principles that are in the OECD guidelines. If a principle is talking about promote equal treatment for national workers and international workers, then you know this actually covers a whole wide range of international labor standards. So that will be the main thread of this week, where we have 2 what I call the technical webinars, like today and Thursday, while tomorrow we have these shorter sessions on Meet the Expert. So tomorrow with Ben Smith on child labor, and on Friday on Martin Oels on indigenous people. So again, also here, they will come in prepared with a few slides on the main topics that they want to discuss on the topic. But if you have any specific questions, please feel free to address them or to write them down on the eCampus. So this week, more theoretical topic discussions, focus discussions on these topics. And next week is where the real work comes in also for you, and where we will have to ask you to start thinking and bring out some creativity on what can we do now, because that is the idea. We're not just having this because these are interesting topics. We also want to see what can be done now. What can you be doing as a follow-up to this training course to put into practice, put into place collaborations or synergies between the different frameworks. And that will be the main part of next week, where we have again a session with Gita and Mario Elena. We also will we invited some participants from the 2019 edition. I wanted to say last year's edition, but no, we already passed the year. This Corona plays a little bit, it's tricking your mind, huh? But no, from the 2019 edition, because they also put in some, they took some initiative, developed some initiatives that they implemented, huh? And that's really where we go for the convergence next week, huh? With then also the closing webinar, where we would like to hear from you. Yes, we will put it also, we will send you, concerning Meet the Expert tomorrow morning, you will receive an email also to access the session, huh? And as said, I really limit this to 1 hour, and everybody is welcome to come in, huh? And the recording we will put also on the eCampus, huh? So if you have specific questions, please write them down, or you can also address them tomorrow. Good. Let's do a small, yeah, let's call it like a recapitulation, a recap of week 1. And we're going to use a Jamboard for that. And for those that haven't used it yet, I'm going to send you a link. So if you click on this link, you should arrive on the Jamboard. And the Jamboard, and I'm also going to it now. So this is the Jamboard for this course. We will be using it a lot more this week and even next week. It's a digital it's an online whiteboard that we can use for brainstorming and so forth. So it's downloading now. Here it is. So what is the ID? You will see here in the sidebar. So yes, I can see that we already have 16, 12, 13 that are joining here the Jamboard. You can here take a sticky note, like I am doing here, and the idea is that you write just on a sticky note one ID, one concrete ID that you picked up from last week, something, lessons learned from last week, an impression, an idea that occurred to you, a reflection, but it has to be with the topics that we discussed last week. So you can take one, and then we can go through them. It's like having a post-it note, and everybody has one post-it note. Write your name on it also, so I can see who it is. Okay? And they should be appearing automatically here on the screen. Good. I'll give you a minute or two to do it. And of course, be careful, you're also owning this page, So you can take care of the post-it note, and that you can use. And don't forget to put your name behind it. I want to see a bit more. Huh? We're now, how many? 23, 20, 16? No, 20 people now. Okay, 1 minute. Anybody else? Like this, huh? Good, huh? Okay, I think this will be fine for now, huh? For those that really want to use to write something here, go ahead, huh? Because I see some like, but good, huh? Hey, let me see, huh? Indeed, huh? We already illustrated that last week, huh? But it is interesting, huh? If you go to the employment chapter of the OECD guidelines and you put that next to the ILO M&E declaration, of course, they are completely overlapping. They speak very much towards each other's, huh? Tripartism, huh? That's also a topic that came up several times last week, huh? The tripartite nature of everything that is being done within the ILO. That's why sometimes things go, I would not say a bit slower, but looking for that consensus many times requires a lot of dialogue between the workers, employers, and government. And it's also one of these ideas that standards, they're not only there to defend the interests of the workers, but also, of course, the interests from the employers. So the standards play the double function. The importance of working together and the need for a dialogue. If you remember well, one of the issues that the reasons that we have this course is because of the initiative of the OECD, ILO, and the EU to strengthen this dialogue between these different actors. So the importance, but also the need to work together. Coherence, that's a word that we used a lot last week. The relationship between guidelines or the principles, let's say it like that, had the principles and international labor standards. The principles of the ILO M&E declaration, these are not, and by consequence also the OECD guidelines, these are not things that were invented like, oh, well, that's a good idea, having a principle on working conditions. No, they are based and grounded within international labor standards. They are good practices that are anchored with international labor standards. And then also here, Jana, from the session that we had on working conditions and working time and hours, that women were the brunt of, were more affected by COVID than men because of the kind of work, because of the sectors that they were working in. Good. Happy to see this, and good that everybody managed to work with the Jamboard. Next week we will be working also more with this tool, and let me put back on here the slide. Anybody wants to add something to what was said, or we continue? Let me open here the chat box. Good. Then I'll hand over to Francesca. Thanks for the input. And Francesca, I'll let you take over the screen, huh?
Good afternoon, good morning, everyone. Thanks, Carl, and nice to be with you and to meet you virtually today. Let me share my screen. There we go.
Yes.
As Carl introduced, today we are focusing on non-discrimination and gender equality and equal opportunities and treatment. We will do so by focusing especially on our main frame of reference in this domain, which is the ILO Convention number 111 on discrimination in employment and occupation. That will be our frame of reference, but then going deeper and deeper into the concept of discrimination, we might branch out to other relevant standards that are complementary to this one. I'd like to start by deep diving into the definition contained in this important standard, which tells us a lot, gives us a lot of information about what discrimination is. As you may know, this convention is one of the 8 fundamental conventions among the huge corpus of international labor standards that the ILO has adopted over the years. And it is one of the broadest, the one with the broadest base of ratification, 175 out of the 187 members of the ILO. So let's deep dive, as I said, into the definition of discrimination. Discrimination is defined, and keep in mind that this convention was adopted in 1958, so quite a long time ago. And it was defined as any distinction, exclusion, or preference made on the basis of race, color, sex, religion, political opinion, national extraction, or social origin, which has the effect of nullifying or impairing equality of opportunity or treatment in employment and occupation. This is quite dense text, but it really does contain all that we need to know to be able to identify discrimination and and all the elements that constitute discrimination. And we're going to analyze them one by one. First of all, we have the distinction, exclusion, or preference. So for discrimination to take place, we need a factual event, an incident, an action that either distinguishes, excludes, or creates a preference. And this does not have to be intentional. It might be inadvertent, it might be unintentional. And this is the first element that we need for discrimination to take place. The second one is the prohibited grounds. We need this action, this factual event, to happen on the basis of certain characteristics or certain what are called grounds for discrimination. So distinction cannot be made on the basis of any characteristics, but we need to identify what are those salient characteristics that identify groups which may be discriminated. And this convention recognized 7 grounds at the time. Over the years and in national legislation, these grounds have been expanded over the years. So we now have disability, age, sexual orientation as recognized grounds for discrimination in different countries and in different other international instruments. Another important ground that is not explicitly recognized in this convention, but it is definitely recognized by other ILO standards, is trade union membership. This is another ground, prohibited ground for discrimination, which is covered by a separate convention, which you might have already covered in this webinar series, which is Convention 98 on the right to organize and collective bargaining. So another important factor onto which discrimination is not accepted. third important factor in this definition is the effect. For discrimination to take place, we don't only need a factual event, we don't only need recognized grounds and well-defined grounds for discrimination, but we also need an adverse effect. There needs to be some sort of a penalization of cost of negative impact on this specific group of people or on this individual for discrimination to take place. This adverse effect can derive both from laws and regulations and norms. So it can be explicit. It can also derive from practices. So it doesn't need to be written black on white anywhere to take place. Sorry, I'm just pulling out the chat box in case. Okay, great. What about sexual orientation? That's a good question. This is among the grounds that have been added over the years in national legislation. Many countries explicitly cover sexual orientation as a prohibited ground for discrimination, and this is quite common right now, but it's also quite recent. And it wasn't recognized in Convention 111 in 1958, but it is absolutely in national legislation and through jurisprudence in many countries. So now we'll go a little bit into understanding what types, let's say, how discrimination can manifest itself and what among these types are recognized explicitly within this standard. We'll do this with a little interaction, if that's okay with you. So a little poll here. We have a question, and I would like you to interact in the chat by telling me whether this case qualifies as discrimination, and if so, what kind. Do you think, based on your prior knowledge of discrimination, do you think this qualifies as direct discrimination, indirect, or structural? And don't worry if you're not familiar with this terms. We're going to see them little by little throughout this presentation. So D for direct, I for indirect, S for structural, and X for no discrimination at all. An advertisement for an opening in a local flyer brigade reads as follows: looking for male applicants aged between 21 and 40. So this is a job advertisement published in a paper or online, and it recites as between inverted commas, looking for male applicants between a certain age bracket. What do you think? Is this discrimination, and if so, based on your knowledge of which kind? Perfect, direct, a lot of consensus on this. Okay, yes, it is correct. It is indeed direct discrimination, and this is what we mean by direct discrimination. When we expressly and explicitly limit opportunities to certain members of a certain group, or on the contrary, when we exclude explicitly certain members of certain groups. So our case example is of the first kind, when we limit opportunities. And as in this example below here, looking for a female accountant aged 45 and 50, also in the previous example, we have different grounds here that may represent discrimination. It may be discrimination on the basis of sex, when we specify one or the other gender, and it may be discrimination on the basis of age, which Convention 111 does not explicitly cover, but as I said, many national laws do cover. So this is direct discrimination, fair enough. Next example, again, your input is needed. The manager in a factory plant informs the staff that there is an opportunity for workers to receive training on leadership, where individuals who perform particularly well may be promoted to become floor supervisors. Training is to take place in the evening after working hours. So here we have a sort of a rule, right? It's not a practice. It's an actual rule, opportunity, or in any case, it's explicitly stated. Sorry, I keep losing my chat box. I'll try and recoup it. Sorry, I keep losing my chat box. Just a second. Okay.
And you lost the screen also now, Francesca.
Yeah. Let me put it back on. Sorry about this. Okay, I see a lot of indirect and a few structural. Okay, we'll see in a second. A few direct, if I'm not, no, this is from the previous example. Okay, it is indeed indirect discrimination. It's not entirely incorrect to say structural, and we'll see it in a minute, but in this case, it is more correct to identify it as indirect. Why is it indirect? Well, indirect discrimination happens when the rule or the situation is apparently neutral. It does not explicitly exclude or prefer, as in our previous case. The situation or the regulation or the rule or the opportunity seems to be open to everyone, but as a matter of fact, there are certain characteristics in the way this opportunity is offered that makes it that makes it not as enjoyable for certain groups of people. So in this case, for example, if you have, again, a job advertisement in which we specify the height of the candidate must be at least 170 centimeters high, tall, this is not necessarily discriminatory openly against any of the groups or on the basis of any of the grounds that we identified earlier. However, if we think that on average, certain groups might not be as tall as 170 centimeters, this might be women are on average shorter. Certain ethnic groups or certain specific descents, ethnic descents might not be on average as high. So in this case, the rule is neutral and does not openly discriminate, but as a result, certain groups might be excluded from that opportunity. Another case of indirect discrimination is when again, the opportunity seems consistent, the conditions seem plain and open and not excluding anyone, but in fact, this opportunity has a disproportionate impact on some specific groups. And this is the case example that we just saw. Training will be provided in the evenings. Here we don't even have clearly and easily identifiable groups, but if we consider the access, the dimension of care responsibilities, for example, then setting such an important opportunity like training after working hours might mean that individuals and workers who do have family responsibilities and do not find it easy to organize for someone else to look after dependent family members, then this might be considered discriminatory indirectly. This is what indirect discrimination refers to, and Convention 111 covers both these types of discrimination. It is a little bit more subtle to recognize and also to prove, but it is indeed important and also covered by this instrument. Another example that I would like to linger on with you is this one. In country X, people of African descent constitute 45% of the population. 80% of workers on minimum wage are of African descent, and university graduation rate is less than a third of that for white Caucasian people. Is this, or can you spot in this case any type of discrimination? Okay, some S's are coming through. Right. Absolutely, that's correct. This is what we refer to as structural or systemic. So the S is applies to both cases, structural or systemic discrimination. This type of discrimination is not explicitly covered in the text of the convention. It is indeed, however, covered later on in other, let's say, comments that the Committee of Experts of the ILO has issued on the topic of discrimination. And therefore, it is important to acknowledge. It is very difficult to pinpoint in cases of systemic discrimination where the discrimination happens. And statistics are the main means that we have to be able to spot where systemic inequalities and systemic disadvantage lies, as in this case. So we know that there is a systemic mistreatment or systemic unequal treatment of a certain portion of the population when these are the kind of data that we have in front of us. And it might not, the discrimination might not be limited to the context of the labor market, but it can be antecedent the labor market. So it can include access to effective and relevant education and training, vocational training, different access to different opportunities in society from a very early age. Questions of housing, social services might come into play. So it's not so easy to really put our finger on when discrimination or where discrimination takes place, and that is why we call it systemic. We call it systemic or structural, when these patterns of inequality and disadvantage are deeply, deeply embedded in the social fabric. And these patterns make it so that certain groups of individuals are systematically put at a disadvantaged position. Another type of or another example of systemic inequality, systemic discrimination, is that of the gender pay gap. We know for a fact that there is no country in the world currently where the gender pay gap is even close to zero, which is quite astonishing if we really think about it. And many studies have shown how direct or indirect discrimination regarding wage accounts for only a tiny portion of why this gender pay gap exists. All the rest of the gender pay gap is accounted for by a variety of different concurrent factors, which are very, very complex to disaggregate and to pinpoint, coming again from segregation of not only of the labor market, but of educational patterns, the training patterns, the way resources are distributed and opportunities are distributed, well beyond the labor market and the moment in which an individual enters employment. So this is another example of structural or systemic, or another example of discrimination, and it's a very important one, and we're going to come back later. The reason why I said earlier that the second example we saw about organizing training after working hours, when I said that it wasn't entirely wrong, that it's systemic, it was because the question of care and care responsibilities and care work, especially when it's unpaid care work, so the work that happens within the context of the family and the private sphere, then it's quite easy for this factor to contribute to systemic patterns of inequality. If we think that, as for the gender pay gap, it is also true that to this day, the great majority of unpaid care work is performed by women across the world. And therefore, thinking about this issue, adopting the same kind of systemic lens may also help us kind of spot where the systemic factors might be. Okay, going back to, let's say, the direct into the core of Convention 111, we're going to talk a little bit about scope. So Convention 111 applies to all persons, so national and non-nationals, to all sectors, public and private, and all types of occupations, including self-employment. So you do not need to hold an employment contract to be protected by this instrument. Also self-employed, and we're talking about individuals like freelance consultants or service providers, or small service company holders, they're also protected by non-discrimination legislation under this standard. It also applies to all stages of the employment process, and not only starting from the moment in which the person is recruited, so throughout the human resources cycle, but also before that. So in accessing vocational training, and also in the way they access employment. So the point leading up to the actual recruitment. Another question for you, as we're going to see a few exceptions to this principle of non-discrimination. This is an interesting case, and it is actually a real case. A pilot for a small airline develops a medical condition that limits his peripheral vision. Because of his condition, he's no longer allowed to fly planes. The airline has very few employees, and there are no other jobs to offer him, and he loses his job. He's let go. Do you think this is discrimination, and if so, which kind? Okay, no discrimination. It's a matter of safety. We have one indirect, one structural. Indirect, no discrimination. Good. Okay. This is actually a real case, as I said. I think it was a Canadian airline, if I remember correctly. And indeed, in this case, the judge determined that there was really no discrimination based on this case. And we're going to see why. Well, someone said that it's a matter of safety, and for sure it is. Of course, the employee could not be left at his original occupation, flying planes. So that would not have been safe. At the same time, the airline was very small, so there was an attempt to relocate the employee in a different occupation, but that was not possible. And this is the basis onto which the judge determined that this act of dismissal, dismissing this employee, was not in fact discriminatory. And this is a case that helps us introduce the idea that there are justifiable exceptions to the principle of non-discrimination, and the basis for these exceptions is reasonability, really. So one case in which exceptions are permitted is when the inherent requirements of the job make it so that that particular and differential treatment is unavoidable. It's really required by that job for that person to be able to see properly, or to be just as tall as specified in the job advertisement, or even though it's more difficult to prove, that this person needs to be of either gender. But we can think of, for example, of personnel who work in segregated services like prisons and detainment centers. Then it might be justifiable that a security guard may be of either gender. So there are certain cases in which the inherent requirements of the job really make those characteristics necessary. We need to be very careful, though, in determining what is an inherent requirement, and the convention makes sure that criteria are set. And especially these cases need to be considered individually. So on a case-by-case basis, we cannot make it a general rule that all security guards in in a detainment center for female detainees have to be female. We do not have to make it a general rule that to be a fire person, you need to be 170 centimeters high. It needs to be considered on a case-by-case basis. Also, the limitations need to be proportioned to these inherent requirements. So there's this idea that you know, once we have identified an inherent requirement, we cannot really go too far. We just have to set that criteria at the bare minimum for that inherent requirement to be met. So this idea also of proportionality. Is everything clear so far? Are there any questions also about previous concepts that I covered? Okay, I'll go forward. So we have another case for justifiable exceptions, and that is special measures of protection or assistance. So special measure of protection, particular requirements of workers. Again, the proportionality principle applies, and one very common example for this is that of reasonable accommodation, which, as you may know, is one of the core principles for the non-discrimination rights of persons with disabilities in the workplace. So this idea that in order for persons with different types of disabilities to perform in employment at a par with non-disabled persons, they're entitled to reasonable accommodations. This may be technical equipment like an aid for the computer, for example, or in the form of a ramp, perhaps as simple as that, or a special chair, etc., etc. This is one example of justifiable exception. It is a differential treatment between workers, but in this case, it serves a purpose. Another type of special measures refers to positive discrimination, also called affirmative actions. Are you all familiar with this terminology? This is quite a controversial. It's usually a controversial topic when we talk about non-discrimination. Positive affirmative actions refer to temporary measures that are put in place with the objective of, let's say, compensating for the underrepresentation of a certain group. So usually they're put in place to compensate for women's underrepresentation, but also underrepresentation from minorities or certain groups in different countries where systemic discrimination may be there. Exactly, Pedro, it is a temporary form of discrimination. So it is a discrimination per se, it is differential treatment. It is also often based on the same grounds onto which discrimination is usually prohibited, but they serve a very specific purpose, which is to really compensate for an existing inequality. And the term that you mentioned, temporary, is really key, because these measures need to be limited in time, and usually they also need to be accompanied by a policy, a specific policy that clarifies and explicitly determines what the rationale between this discrimination, positive discrimination, is, and also that sets this very specific time limit accompanied by a target. So we can say that in a company, we have a historical underrepresentation of African Americans, and we want to really remedy that. And we have a diversity policy that sets a target of reaching, and here I'm using a random digit, but 30% by the year 2025 of African American employees And therefore, in the recruitment process, we decide to consider or to award positions to persons of African American descent, provided that their qualifications are equal with other candidates, for example. So this is temporary, and it also this principle of proportionality applies also here. So the target of 30% and the nature of the positive discrimination needs to be proportioned to the underrepresentation that we are trying to correct. We cannot decide to have a whole women company because women have been historically underrepresented. It needs to be proportionate, and it needs to be reasonable based on the overall rationale. Is everything clear? Good. So when we are discussing positive discrimination and affirmative actions, we are in the context of so-called equity measures. You might have heard also this term. It's important to make this distinction between equity and equality. When we are discussing non-discrimination, usually we are in the context of equality. When we are talking about positive discrimination, we are in the context of equity. Equality refers to sameness. When we are trying to give the same thing to everyone, this is when equality happens. However, for equality to work, we also need to have a situation of sameness in reality. No, everybody needs to start even. And this picture, I'm sure you might have seen different variations of this picture going around the web. These pictures really exemplify this. So if everybody is given the same, but they're starting from a very different position, that really does not help them. It might actually end up perpetuating these differences, and we are not really achieving a situation of de facto equality. When we are in the context of equity is when we understand that we might need to give people different things in order for them to have equal opportunities. We need to level out the playing field, so to speak, and this is what equity measures are for, again, with those conditions that we mentioned earlier. So we might say that equity is the means. Usually this is what we say. Equality is the overall goal, and equity is one of the means to achieve it. There's also an additional picture to this series, which is this one. And sometimes we tend to think within the boundaries of what the reality is given us, right? Of how the reality is presented to us. And sometimes it takes a little effort to think that obstacles do not have to be there. You know, we're focused on trying to overcome them, and sometimes we lose sight of the bigger picture, where we really need to focus on removing the obstacles altogether. And this is what we call systemic change or systemic equality. And this is to recall the question of systemic discrimination that we mentioned earlier. So in order to tackle systemic discrimination and systemic disadvantage, what we really need is to go to the deeply rooted causes of inequalities in a given society, in a given workplace, in a given context that we are working within. There is one last justifiable exception. It's perhaps less relevant, but still worth to mention, which is when individuals are suspected to be engaged in activities that are prejudicial to the security of the state. So one example of this, relatively recent, or in any case very relevant in the contemporary context that we live in, is that of anti-terrorism measures. this may qualify to be exempt from the principle of non-discrimination. Are there, sorry, I'm reading the chat. Are there exceptions or rather no discrimination, absence of discrimination? I'm not sure if I understand correctly the question, Marianne. These are exceptions. Well, discrimination is there, so it's not like there isn't. There is, all the three elements that we analyzed earlier in the definition are there. So as a matter of fact, discrimination and differential treatment does take place, but the exception is whether this qualifies legally as discrimination or not. So there is a differential treatment on the basis of certain grounds, but this is exempted from being considered a negative form of discrimination, a harmful form of discrimination. Did I clarify a little bit?
A little bit, but I am not so satisfied because I worked on this myth before, and for me, there's a difference between the fact that there is no discrimination because the elements are not there. Just I see in the convention that it's written that there is no discrimination, and for me, it's the difference between that and the fact that there is a discrimination, but we accept this form of discrimination for reasonable and proportionate reasons. So for me, perhaps it's conceptual difference, but theoretical difference. But in the IU frameworks, it's written there is discrimination. There is no discrimination in this case, and the fact that there's an exception is there is discrimination, but we accept for those reasons. And here in the text, I see there is no discrimination, but perhaps that has no effect. But yes, it's perhaps a theoretical definition.
No, I understand your point, and I must say that I am not a jurist, so I'm a little hesitant to provide an answer on this because I think really this is a question for let's say a juridical philosopher or maybe a theorist in any case of the law. But this is my view. I understand the subtle difference of distinguishing between no discrimination exempting from it is discrimination, but we accept it, or there is no discrimination. I think that the negative effect, the third element that we analyzed earlier, might provide some insight into this question. In the case of positive discrimination and affirmative action, how can I say, the negative effect that we need to be there for discrimination to take place is like it's lifted, meaning that affirmative action responds to a higher good, let's say, which is compensating for existing inequalities and remedying existing inequalities. So let's say the negative impact of that discriminatory action is sort of nullified, I would say. Maybe it's not the right term. In other cases, I think it's really a question of legal terminology, but actually if there are any jurists in the audience, more than welcome to step in. But I think what we can consider legally as discrimination covered in this convention, then there's no discrimination in that sense. I see, oh, it's you, Marianne, who came on camera. I will try, perhaps I'll try and ask around to some colleagues who may have the specific expertise and get back to you on this one, maybe through Carl after the session. Is that okay?
Yes, okay, thank you very much. But I hear you, and your explanation is also interesting. This is no problem for me, it's just a reflection. Okay, thank you very much.
Thank you. Okay, so yesterday you might have received via email a case study. I hope that you managed to read it beforehand, but otherwise we can go through it together. This is a very interesting case, and it's a real case, and we will reveal the details of this case in a minute. And it gives us the opportunity to talk a little bit more about the different grounds and how the discussion over different grounds for discrimination and disadvantage has evolved over the years. So let's give a look at it. I will tell you briefly what the case is about. Basically, in 1976, and we are in the US, 5 African-American women sued a large corporation, and I can reveal to you that the corporation is actually General Motors, for a seniority policy, and they argued that the seniority policy was discriminatory against them. In the 1970s, we all know that a huge recession hit the world, but especially the United States. And General Motors decided to let go a number of people. And in this layoff campaign, they decided to base on the aspect of seniority to decide on which criteria to lay people off. So they laid off all staff that were hired after 1964. Usually the first come, first served basis is often applies in layoff campaigns. Because of racial laws that had been in place until the late 60s, all African-American women working at General Motors had actually been hired after 1964. So as a consequence of this policy layoff campaign, all of them were actually let go from General Motors. Exactly, Pedro, 1964 is the year that the Civil Rights Act was signed. So this is the fact. There are African-American women in General Motors. They were all hired after 1964. And in this layoff campaign, General Motors decided that everybody who were hired before had to be laid off on the basis of seniority. This women sued, and there was obviously a sentence over this case, but I wanted to discuss with you well, first of all, whether you think this is actually a case of discrimination, and if so, of which kind, indirect, direct, or structural, as we discussed earlier. And also, in case it is a case of discrimination, what is the ground, or what are the grounds on which discrimination took place? Okay, Pedro says it seems indirect, right? Indirect and structural, Kamala? Yes, indirect. We have indirect and racial, direct or structural. Pedro says there's consistency, there's a seniority policy. These are all actually a good point. It is, in fact, well, first of all, yes, I mentioned that it is General Motors. The first question, direct or indirect? It is indeed indirect discrimination. The policy didn't mention race or gender, or it wasn't directed at any particular group. It was decided that it was on the basis of seniority, quite an objective criteria. So apparently a neutral rule, a neutral decision, but it did have, apparently, this is what these women argued, a disproportionate effect, though indirect, on a specific, and in this case, a very, very specific group of people. You mentioned racial discrimination, and this is certainly one of the possible grounds. We also have the gender factor here. We know that these are women that were let go, and well, seniority is one of the other factors, but in fact we can exclude it. We now have in competition race and sex. Well, great. Stephanie mentioned the magic word, which is intersectional, racial and gender. Intersectionality is the key word here, and we'll explain it in a second. So basically, we have either sex, and if we wanted to establish whether discrimination based on sex took place in this case, we would have to compare men and women, right? We would have to establish whether differential treatment took place on the basis of these women being women, basically. But as a matter of fact, there were other women who were employed by General Motors who were not discriminated against. They were not let go. So it is not entirely a discrimination based on sex, because not all women were involved and not all subgroups of women were involved. On the other hand, if we consider race on its own, we would have to compare all African Americans employed in General Motors and all non-African Americans employed. And even in this case, we wouldn't be able to prove that a differential treatment did take place, because not all African American employees were let go. Only women were let go. And this is what is called intersectional discrimination. It's when there are two grounds that kind of mix together and that are just opposed, one on top of the other. And the group that is discriminated against is really the intersection between these two groups. It's not all African Americans, or it's not all women. It's only African American women in particular. And this is something that may appear, how can I say, kind of obvious, that not all women are the same, or not all employees are the same regardless of their race. But especially from a legal standpoint, this was very difficult to recognize up to a certain point. And actually, it was a civil rights lawyer in the United States who in the 70s exposed these kinds of cases, like the one against General Motors, and invented the term intersectionality, and really started to look into this aspect of how the law didn't account for this very specific types of discrimination, and how we needed to go a little bit beyond the recognition of separate grounds, and in order to be able to really account for these types of disadvantage. Great question, Pedro. This is the ruling for this case. Well, first of all, this is what Kimberly Crenshaw defined intersectionality as: the overlapping of different types of discrimination and disadvantage. This was in the 1970s. This term has grown and evolved over the years to mean more than this, meaning that it kind of went beyond the limit of jurisprudence and legal case law, and entered also the realm of development and social studies. So intersectionality now is used also as a lens to really understand how oppression and systemic disadvantage is structured in different societies, and who is being left behind these different structures of power and oppression. So it's really become a larger term, or in any case, it's come to apply to a broader domain. And this is the original judge's ruling at the time, so 1970s, let's bear in mind. It was not possible. It was made, a request was made at the time to bind together these two grounds. So to create a special class, to recognize, for the court to recognize a class, a specific class of African-American women in order to be able to consider these grounds together. But this was decided it's not appropriate at the time. And the lawsuit was presented on two separate grounds. And on both grounds, the judge ruled at the time that there was no discrimination proven. Just because, as I said, other women were not let go, and on the other hand, African-American men were not let go. Things have changed. Probably almost certainly a judge today would have a different ruling, but this is what happened in the 70s. In the 1970s, we could consider different specific groups only on the basis of one single characteristic that may determine discrimination. So in that case, those women were considered only as African Americans or only as women, and this allowed for them to kind of fall through the cracks of case law. So sometimes during training, when we deal with the issue of intersectionality, I hear a lot that it's a fancy word, and it's a complicated term that doesn't really have any practical application. But I tend to disagree. It really is a reminder that there is inequality also within inequality, and we really need to be mindful of this to be able to spot, according to which context we're working in, really to spot what are the relevant grounds there and how these grounds combine together in a given society, in a given workplace context, in a given sector that we're focusing on, how these grounds combine together to create patterns of inequality and disadvantage. And this is an important guide for us when we're trying to tackle those inequalities and to write policies and draft measures to make sure that everybody enjoys rights equally. So I put in the slides also a link to an interesting article that talks about Kimberly Crenshaw and how she worked for 30 decades over this concept applied to especially civil rights in the United States. If anyone is interested to go a little deeper. Sorry, I think I might have missed a question. Was in the case that there are African American males hired before 1964 that were not dismissed? Yes, apparently that was the case. Not that they were not dismissed, but the fact that there were women, this I have not gone deep enough, but maybe I can find out that racial laws apparently put restrictions also on African American women in particular being hired in certain sectors like the automobile. So I think this was another factor in this case, that it happened that mostly women were hired after 1964, and discrimination didn't apply to African American male in that case, because there were many of them that were actually employed before. This is, but I will check and let you know, John. Okay, everything clear? One final note on Convention 111 is on sexual harassment. Sexual harassment was not explicitly covered in Convention 111 in the actual text of the convention. However, it was covered by the Committee of Experts on the Application of Conventions and Recommendations, which is the main body that monitors the application of all ILS instruments. In different comments over the years, actually, the committee mentioned sexual harassment, and finally in 2003, it explicitly recognized sexual harassment as a serious form of sex-based discrimination. This was not new, meaning that many national systems through case law and jurisprudence had already acknowledged and had already treated and dealt with the sexual harassment in the context of anti-discrimination law, but officially at the level of international labor standards and international law, it was officially acknowledged in 2003. There are two forms that are explicitly recognized, and also at the level of national legislation, this is also consistently found. There are two forms. One is sexual blackmail, also called quid pro quo, which means this for that, and it's quite literal in its meaning. It means when things are promised or opportunities are denied on the other hand, on the basis of sexual favors being exchanged. So a very quid pro quo kind of transaction. I'll give you this if you give me that. A different kind, a little more subtle to establish, is that of a hostile working environment. When the culture of a workplace, of a specific unit or specific office, or even a relation between individuals is made hostile by comments, innuendos, jokes that have a sexual connotation and that make one of the parties involved extremely uncomfortable, or they make them feel like their dignity is being violated or humiliated. Hostile work environment, as I said, a little more subtle to spot and to prove. Sexual harassment is now also covered by Convention 190, which was adopted in 2019, on violence and harassment in the world of work. This convention is actually, it does not cover only gender-based violence or sex-based violence or sexual harassment. It covers violence and harassment in the broadest possible sense at 360 degrees. But it also applies a so-called gender responsive approach. So the gender dimension of violence in the workplace is clearly acknowledged. And among these types, sexual harassment is also clearly acknowledged in that convention as well. Reading the chat, because I used an example, women were hired for front office jobs only so that they wouldn't hire African-American women. Well, African-Americans were only hired for back office physical jobs were only offered to men. Yeah, it sounds likely. Unfortunately, another type of discrimination where more than one ground applies. Different kinds of discrimination applies to different gender based on their race in this case. Another question by Pedro. This consideration of forms of sexual harassment are neutral towards sexual orientation or focused only on protecting women from this form of sexual harassment? That's an excellent question. No, actually, it does not. All these provisions do not direct to either gender in particular. So sexual orientation is not explicitly mentioned, but it really doesn't matter. Sexual advances or hostile work environment might be generated on the basis of jokes, innuendos, offensive kind of gesturing on heterosexual or gay kind of undertone. So no distinction there. And also the Convention 190 on violence and harassment applies the concept of gender in the broadest possible term. So it does acknowledge that there is a gender-specific component to the issue of violence, meaning that women are statistically disproportionately affected as victims. But it also acknowledges the power component to the concept of gender. So it does not really specify that we're talking about gender violence against women or violence perpetrated by men onto women. It can be violence from women to women, from men to men, and sexual orientation really shouldn't matter. And all types are covered. It really, the sex of the person, whether it's the perpetrator of the victim, at some point is I'm not saying it's irrelevant, but it doesn't matter. It will cover even non-binary genders. Yes, I think this is actually one of the most innovative aspects of this new convention, 190. It was a hotly debated issue, this one that you mentioned about a non-binary conceptualization of gender, and also the issue of sexual orientation. It was a hotly debated issue during the discussion process that led up to the adoption of the convention, that lasted for 3 years in the International Labour Conference. So really, this convention went through a lot of stages and of discussion to reach a consensus. But eventually this form was decided and was agreed over. Sexual orientation or let's say the other stances from the LGBTQI movement were not explicitly mentioned as a way to avoid caging specific groups into, let's say, this categories of vulnerabilities. It was decided instead to adopt a broad conceptualization of gender, which acknowledged the question of power relations and of systemic oppression as a way to include all sexual orientations and also non-binary gender identities, and to protect them from all forms of violence and harassment. Since the C-190 new has not been ratified by many countries yet. No, not many. We have 3, if I'm not mistaken. I think we are on the verge of having 4. There is Fiji was the first country that ratified, and Uruguay followed very shortly within the first, I think the first year after its adoption, actually for 6 months, I think, after its adoption. And then we recently have Namibia, so first African country. I heard there's another Latin American country who's started the process of ratification, but not yet concluded it. So we have almost 4, and that I think will be Argentina, if I'm not mistaken. I think that also some European countries are taking the first steps towards certification, which imply running a sort of a country level mapping exercise, assessment exercise of the current state of the legislation and policy, and other more formal steps to enter the ratification process. But there are countries that are taking those steps. Could you say if these sacred comments, observations have often been referred to in court cases of sexual harassment? I'm not able to answer specifically regarding case law, but this is something I can surely find out, and through Carl let you know. I would dare to say yes, meaning that this is what often happens with the comments of the committee of experts, that they are as authoritative as the actual content of the convention, and therefore they do provide direction to national legislation and also to national case law. So I would imagine so, but I would check and let you know. Okay, so this is actually the end of my content part of the presentation. I thought I would end by giving you some practical elements to follow up on yourself on this, if this is something you're interested in, to go a little deeper into the question of equality and non-discrimination, in this case, with a specific gender focus. In the course of the past year, we have developed a number of tools targeting specifically the private sector and the policymakers who work directly with the private sector. So I think this audience is might be particularly receptive. And it's within a broader project that is managed by the ILO and UN Women, and it's called We Empower 7 countries. And the ITC has developed a capacity development platform, which is free and open. The link is included in my slides. It's called Empowering Women at Work. And it contains a package of different tools that you might find useful. There is, first of all, a self-assessment, a gender self-assessment questionnaire that companies can fill in. It's thought of for private companies, but public institutions might also benefit to take the questionnaire, and you receive some feedback giving you a few pointers and on the areas that you might need to focus on in particular when it comes to tackling inequalities at the workplace level. And it also gives you some advice in terms of how to fill this gap through training. And it offers, therefore, the next step, it offers some thematic modules that are open and free. They last 45 to 60 minutes, and they're self-guided, so you can take them in your own time, leave them, and then take them again. They focus on 3 topics, and this project specifically focuses on women. The topics are pay equity, which we touched on briefly before, violence and harassment, and work-life balance and care policies. And these 3 topics are dealt with in 2 separate sets. One set is for company managers and HR managers, so targeting specifically the level of the company, of the workplace, and the other set is targeted at policymakers who have to provide that enabling environment, policy environment for the private sector to thrive, while also respecting women's empowerment principles and non-discrimination principles. So the next step further is to benchmark your company. If you have taken the test and you have left your data, you can benchmark yourself with other countries, other sectors, or other industries. And the next step again is, if you need to, is to be able to refer to the business business help desk at the ILO, which I'm sure you've become very familiar at this point of the course. The business help desk is collaborating as well directly within this project, so it continues to provide assistance on this as part of a much broader range of issues to ILO constituents. So I hope this gives you also something to follow up with in the future. I will stop here. And I've taken notes of outstanding questions that I might address through Carl later on. Thank you all. If there are any questions, I am free to answer them. I'm sorry, Carl, I went a little bit over time. Apologies for that.
It's fine. Thank you, Francesca. No, thank you. And we still can have some questions, huh? If there still are. So that's what I would like to see, if we still have some questions on the topic, huh? So let's maybe give it a minute to think about how to let it digest.
Sure, I'm here. And also, if questions come up later on, feel free to reach out directly or through Carl.
Then I'm going to share my screen already.
I have a question.
Yes, go ahead, please.
Hi. Maybe you mentioned it, but maybe I missed it on the case study that you sent us. So, because at first sight, this measure by the company seems not discriminatory,
Mm-hmm.
but should the employer, when applying such a measure, check whether a certain group unintentionally maybe is affected disproportionately?
Yes, that would be an excellent practice. I mean, we saw how for discrimination to take place, intention does not necessarily have to be there, and sometimes it's. I mean, most of the time it might be unintentional when it's indirect discrimination. So. We might not realize that apparently neutral rules might have a disproportionate negative impact in certain groups, and this is something that actually I tend to repeat in this kind of context, because really, especially when it's about the private sector, it's so important to remind them that it's not their fault most of the time when inequalities are there, but at the same time that so they can change things. So this is a good example that you mentioned. There is no guilt, let's say, in some cases when there's no intentionality, and checking might be a good practice. So the example of setting the time of a training after working hours is really much more common than we would think of. And you know, I also do it inadvertently sometimes to, you know, when I set up a meeting in the second portion of the afternoon with a large number of people, and I don't worry that colleagues, especially in other institutions where they may have different working hour habits, certain colleagues might not be as flexible in their schedule, and they might have indeed family responsibilities to attend to. They might be part-time workers. So it's really sometimes about checking our default mindset about things. Of course, when it comes to planning a laying off campaign, then of course, you know, doing a little bit of due diligence on the possible effects that this major measure may have is a good practice for sure.
Okay, so it's not an obligation from a company to check this when they introduce such a measurement.
Well, I'm not an expert in this, but I would say that it's in the interest of the company to check also from the standpoint of legal liability. If there is a possible case of indirect discrimination, this might also be very costly. So it is a good practice also in that sense. It is all, I mean, mostly it is a human rights issue, but it is also there's also a business case there for sure.
Yeah. I have I'll show it to you. I'm actually here looking at the website. There is the Help Desk also published a note, especially today in the crisis that some companies are facing because of COVID-19, that they are forced into restructuring. So what are responsible restructuring strategies that companies can take? There is a paper on this topic that is available on the Help Desk for Business that also provides you, Kamala, this kind of guidance. What are the kind of actions that companies should undertake when they want to restructure in a responsible manner? So I'll actually quickly will check for that. I think even in the previous training course, this was actually a topic, a specific topic, a focus session on responsible restructuring and hiring and firing practices. Good. Yeah, if other NCPs, Katerina asks, are there any other NCPs that have handled on specific instances on gender discrimination? Anybody? Because that's a question for the group. Okay, I'll let you think. And this is here the link towards the article on restructuring for recovery and resilience. Okay, non-discrimination so far has not been the topic of a specific instance in these countries at least. Okay. Okay. I believe also it was more freedom of association, collective bargaining that are more recurrent. Good. Any other question maybe, or maybe Katerina, you would like to add something?
Yes, thank you. I think it was a very good presentation. I think it's kind of strange that, given that the guidance documents, particularly on responsible business conduct in the agriculture sector and in the textile sector, focuses a lot on gender discrimination and possibilities for gender discrimination in these sectors. So we'll probably see more complaints on that. But I was actually thinking more about sexual harassment. I just looked in the OECD complaint database, and it seems that Poland had one, but it is really old, from 2002. But if anyone can think of something, then I can't really comment on why I'm interested in this, but I guess you can take a guess. But if anyone has some examples, I would appreciate it. Thank you. And also the court cases examples, if you could look at it, how it has been used in sexual harassment court cases, it would be very useful for us. Thank you.
Thank you, Katarina. Catherine. Yes. Okay, Francesca, you would like to add still something?
No, really just thank you all. It was great being here. Please do reach out if questions pop up later on and be in touch. Thank you, Carl, for having me.
Yes, and I put here your email address also, Francesca, in case somebody wants to have a quick follow-up question for you, and you can always direct them then in the right direction, if there's any further question on that.
Of course.
Good. We're good on time, so let's go to the conclusions of this webinar, starting with again a short assignment which prepares you for the session we have on Thursday with Karen Curtis on the freedom of association and collective bargaining. I hope these little sessions are interesting for you. They are actually part of a broader training package, which we also will share with you later in the week on responsible business. It's a training package which we developed to provide guidance mainly to SMEs, but can be used for anybody on responsible business practices in line with international labor standards. So one chapter is on freedom of association and collective bargaining, and it gives you already should give you a good understanding of what this means, these topics, and what it means for companies. Don't be shy to post questions in the forum. We already have a few on indigenous peoples in ILO on Convention 169. If you have any specific questions for tomorrow on child labor, think about it. We already had one on mitigation, I believe, or remedy, access to remedy. So that will be for tomorrow afternoon, and Friday with Martin Oels on Convention 169. So this is what is on the schedule then for tomorrow. We will send you an email probably tomorrow for the Meet the Expert session. I hope we will have a good group there. And I'm sure it will be interesting with Ben Smith on child labor. He will answer he will introduce the work that he is doing. He also will talk about the guide on child labor that was developed and I think was launched last week on the Human Rights Due Diligence Forum. So that's for tomorrow. It's only 1 hour from 3 to 4. And then we have the webinar, the technical webinar with Karen Curtis on Thursday afternoon from 2 to 4. So thanks everybody for being here with us. I hope you enjoyed it. And if there's anything, of course, feel free to send us an email or to put it onto the discussion forum on the eCampus. So we see each other then tomorrow, if you feel like, tomorrow afternoon at 3 p.m. Bye-bye. Thank you.
Thank you.
Bye.
Bye. Thank you.